Thank you so much for the introduction and for giving me an opportunity to speak here a little bit about our priorities, our challenges, and a little bit more focused on AI regulation. Maybe I'll start with sharing the presentation. So, okay, there we go. So I hope this is visible now for everybody. Yeah, as I said, I will try to give a little bit of a insight on what it is, what is the situation of a DPA from a smaller member state is right now, what challenges we face, and how we try to address them as well. And then at the end, I will try to talk a little bit more targeted on the coming AI Act and our possible role, so the role of a DPA, but especially the Austrian DPA in this governance structure. Maybe one or two sentences once more about myself and especially the department I work in. This department was kind of created to handle everything that is kind of not day-to-day business. That's what I usually call it. We handle especially mass actions, so mass procedures. These are procedures that have a similar controller, similar legal questions, but many, many complaints. So we receive many complaints that essentially pertain to the same problem, the same legal question, the same controller, and we try to handle this in a smaller team to do this most efficiently as possible and do this in a concise way. But also in this department, we handle essentially the monitoring of all EU legislation that pertains to data protection, or where there's like an interplay with data protection and where our DPA has a role. So where our DPA is affected, but also everything to do with the large EU databases, such as the Schengen Information System, where right now we experience a lot of complaints. So everything legislation with these large EU databases, we also handle in this department. But now I would say we go right into it and we start with the fun part, the challenges. And here, as you might expect, I will start with the numbers because this is just by far, and there's no hiding it, our biggest challenge. What I've prepared here is a table going back to the last 3 to 4 years, containing the numbers of the complaints under Article 77 we receive. It's important to note that these are just our national complaints. So complaints where the controller is also in Austria and there's no one-stop shop. So everything one-stop shop where the controller is in another member state, or even there's no one-stop shop, but the controller is in a third country. This is not included in this number, and ex officio investigations are neither. So as you can see, in 2022, we received close to 2,000 of these complaints, while in 2024, we are already at 3,000. And I looked it up the other day. Right now in 2025, we are, as of end of August, we are already looking at well over 3,000 complaints. So there's a good chance we shatter our previous record, I might call it, by the end of the year easily. So you can see that the curve we are looking at is quite steep and it's just going up. So there's no real fatigue in complaints as you maybe might want to expect. It's just the other way around. It goes up quite a bit. What we've noticed that what increases a little bit are these mass actions, mass procedures that I've already explained. So this gives you a bit of an insight how this number comes to fruition. We notice a bit of an uptick in having a lot of citizens, a lot of data subjects represented by law firms that are doing these mass procedures that are often kind of a pre-procedure, I might call it, for a possible civil lawsuit or damage claims. So right now, to give you some insight, we have several dozens or maybe 100 complaints about where the controller are like gambling companies, where the idea is for data subjects to get their access to their information and then possibly reclaim some of the money they spent with these companies. Same thing, hundreds of or a few hundred of complaints about telco providers, for example, that have service fees. The background is that there is a decision now in Austria where like service fees or hidden service fees are deemed illegal, broadly speaking. So they are also using their right of access to get information about their payment history to then possibly reclaim this in front of a civil court. And then we also have a few hundred complaints where this pertains to controllers, where there might already be a decision by us that a certain processing was deemed illegal, and the complaints are now having this idea to go for immaterial damages. So first, get a decision by the Data Protection Authority, and then possibly go to a civil court, and then try to only have this procedure about the damages. I want to emphasize that these are perfectly legal and perfectly valid complaints. Like this is also what the GDPR and data protection law is also about, and especially the right of access to get information that you can then also enforce other rights that you might have. But I'm trying to just give you a bit of an insight how this number comes to fruition. Having said that, the regular complaints that we have been receiving since 2018, these are still the large majority of the complaints we receive. So your classic video camera, your classic somebody wants to get their data deleted by a credit agency or by a bank, for example, these are still the vast majority of the complaints that we handle. There's also something a bit different, I think, with certain DPAs than there are with others. So if I talk to my colleagues from other member states, they're telling me, at least some of them do, that the culture of complaints is a bit different in their country. So in Austria, and I believe it's a bit similar in Germany, there's a really knowledge of a regular citizen that there is this possibility to bring a complaint to the DPA to enforce your rights, and that is also free of charge. While this is maybe not as much the case in some other countries, at least that's my experience for now. What we've also noticed a little bit is that at least for some complaints, but these are like special complaints, there is an increase in technical complexity. This, of course, also has a little bit to do with civil organizations such as NEUB, that is this privacy NGO by Max Schrems, which is established in Vienna. So there is this connection where we are very likely to receive a bit more complicated or groundbreaking cases that we are now receiving. And here we are now noticing, okay, a lot of times they have AI as a topic, and it's a bit more technical complex, I would say. But this is a small trend that we notice a little bit. So this is for the numbers. This is just by far the sheer amount of numbers is a challenge that smaller DPAs such as ours are facing and having a bit of a tough time to handle at times. And then we have the additional tasks. So I've just listed here a bunch of EU legislation, but also national legislation. Some I haven't even mentioned, DSA, DMA, where we are not the competent authority, but of course still have a little bit to say and to do in certain cases are in contact with the relevant authorities. But here you see a lot of these acts where we might have a role, or we will certainly have a role. From a national standpoint, I also have included this Freedom of Information Act. This is quite new in Austria. I know Austria is quite late to the party in this regard. Even though there's no competent authority as such, maybe like there is in other states, there are several tasks that DPA, like the Austrian DPA, has to handle in this regard. The big one, of course, that is coming is the AI Act, and I've already mentioned I will get to this a bit more later in detail. The challenge here is also that a lot of these acts don't have, even though they are regulations, they need accompanying laws. Like they need a national law to designate the competent authorities and to handle the penalties, for example. And a lot of times we don't have these accompanying laws yet, even though the regulations are already in force or will be in force soon. So there's this challenge where you kind of have to prepare, and you're a bit in limbo, where you don't really know as an authority what will be your actual tasks in this regard. This challenge also kind of goes to the European level. So we have now seen in a lot of subgroups of the EDPB, of the European Data Protection Board, we deal now with guidance that we want to provide on the interplay of the GDPR with these new laws that are quite complicated, of course, and the companies that are being regulated notice the best that this is not always an easy task. So we, of course, provide or try to provide guidance in this regard. But yeah, this also takes quite a few resources and is now a big topic in the subgroups of the EDPB as well. So this is, of course, not just a national challenge here. So now that I've mentioned these two broad topics as challenges, numbers and additional tasks that are coming, let's see the counterpoint. You see the numbers, you see the additional task versus the resources. And as you all know, the resources topic has been a problem for DPAs since start of the GDPR and even before. In Austria, the situation at the moment is like this. We have a few years ago have gotten an increase in our budget, which was extremely helpful. We did not in the last few years, of course. And as you can see, as you already saw, there has been an increase in tasks and just in the sheer numbers. So over the last 3 to 4 years, just the national complaints have essentially doubled. The situation now is like this in Austria. We have a budget for 2 years, and in 2026 we will face a budget reduction. And there's, if you're being realistic, no real chance for an increase in the coming years. So this will lead to a de facto reduction of personnel, especially like internships, where we will just not be able to have this position in our budget anymore. So much for the pity party and the challenges. Now we go a little bit into our priorities and how we handle these challenges. For these mass actions, mass procedures that I've mentioned, we have created now a team that is quite experienced and is relatively small, so it doesn't really take resources of a lot of lawyers that we have, where we try to deal with these mass actions in the most efficient manner. That is the idea. So we have already quite some experience now with these kind of procedures and have realized in a lot of them it's really good to have one pilot procedure where we try to establish the facts. We usually have oral hearings. We try to, if it's necessary, we try to have technical experts involved and have a very early a good idea of what the relevant facts of the procedure are and try to facilitate a timely decision here. We not only have this experience now on a national level, but also on a European level. So the Austrian DPA has chaired, for example, the so-called cookie banner task force on the EDPB level. I don't know if how many of you remember this, but this was a mass action kind of or mass procedures brought on by NOIB a few years back about the compliance of website providers with cookies, essentially cookie banners, and the legal basis for that. So we've chaired this and tried to give our input there. And now I feel like quite a bit of experience with these kinds of procedures, and they have gotten quite a bit more efficient over time. And we're quite happy with our progress in this regard. The idea is then, of course, to have one of these pilot procedures and then bring the facts that you found into the other procedures and have these decisions more or less the same. Of course, sometimes some facts vary and you have to adapt a little bit, but the idea is here to do this in the most efficient way and to not waste a lot of resources. From an ex officio standpoint, so where there's no complaint, we try to do quick fixes for smaller violations. I'm now thinking of a citizen is bringing to our attention that there's a camera that is slightly also filming like public ground. There we try to have awareness raising letters. This is also, for example, on a website, we noticed there is not enough information on the Article 13, for example. Here we are trying to not have a very resource consuming formal procedure, but I have the idea is to have awareness raising letters, and we've had some very good experience with that method. Of course, we do have ex officio actions that are quite focused. So from now on, or starting next year, we have this idea that we do concentrated, focused ex officio actions on certain aspects of the GDPR, which we will communicate at the start of the year. For example, in the past, we did this with sectors. So we would look at certain sectors and then have actions there on the whole GDPR. We are thinking of moving away from this and be not sector specific, but more looking at certain aspects of the GDPR to also have this a bit more focused. That is the idea. Also, a big topic for us is we want to share topical, technical, and domain knowledge, and also, of course, receive this. So we have an increased cooperation with other data protection authorities. These are, of course, mainly authorities that are maybe in a similar situation as us, so from smaller neighboring countries, but of course also the ones that speak the same language as us, as the German authorities. But also others that we have a relationship with. So this is very helpful. But we also have this now with international data protection authorities. For example, we had a call on a European level with the Korean Data Protection Authority on a case which was extremely helpful. So this is what we are trying to building, because we feel like this is just a very untapped resource that we want to really focus our attention on. But also we have an increased cooperation with national authorities from other areas. So market surveillance authorities, telecom regulators, media regulators. This is very helpful for us because they have domain knowledge that we want to tap into, and the other way around as well. So for this reason, we have kind of founded this, in Austria, you call this Digitalisierungsnetzwerk, so a network of digitalization, where all the independent regulators in this area come together a few times a year, foster the relationship, and exchange information. And we found this very helpful. This will also be quite important for the future, also for stakeholders, for companies, that these authorities do not act in silos without knowledge of each other, without exchange of information. So having said this, having talked about priorities and challenges, I want to now go a bit into the AI regulation, where we'll also, as you might notice, come back a little bit on these challenges and priorities, because they are important when it comes to the coming AI regulation. As you might know, this DI Act is now gradually becoming applicable. The AI board took up its work. Prohibitions on the Article 5 are already applicable. And in theory, the authorities, the competent authorities under Article 70 would have to have been designated by early August. In a lot of member states, this has not happened. Austria is one of them. For DPAs, there's the special provision of 74.8, where the idea is that DPAs are being designated in some certain very sensitive areas. I know in other member states this will not be the case, but we assume that we will have quite a big of a role here. The challenges. We don't have an accompanying law passed at this point. So there are no authorities designated. There's no official mandate yet. There's a high level of technical and domain knowledge necessary for this. So experts will be difficult to attain regardless, not only because the technical experts will be hard to get on the open market, but also because the domain knowledge is very necessary. For example, AI expert in regards of biometrics will maybe not be so helpful when it comes to other prohibitions, for example, or high-risk areas. So this is quite a challenge, and we assume that a sort of pool of experts where all the competent authorities can tap into could bring a solution to this a little bit. I have to say, of course, we are in constant contact with the federal government, who is responsible here for the introduction of the AI Act. They are very, very helpful and give us information, but ultimately this is, of course, a political decision. And without the mandate at the moment, it's a bit difficult to act, because if you have no time and resources to prepare, it's hard to already prepare also for the actions that you might want to bring. The idea is at the moment you can almost try to anticipate the designation. For certain areas, we are a bit more certain that we will be a market surveillance authority, we will have competence. For others, we are not. So what we do right now is we use the resources that we have in the most efficient manner. we do capacity building as far as possible and where we already have a mandate. So, for example, from a data protection standpoint, in this interplay with AI, we are chairing the so-called ChatGPT task force on the EDPB level. We are taking part we took part in the 64 opinion on the EDPB opinion on anonymity in AI models. We now have quite a few complaints, also in part because of NOIP, that are AI related and have an internal task force that is handling this. We are already now trying to establish ties with the main national market surveillance authorities to build capacity there and try to, as I said, build capacity in the areas we are confident we will have a mandate. So, for example, these areas of 74.8 that I mentioned, and for example, the prohibitions. What is also very helpful is in Austria, there's a AI help desk at the telecom regulator already established, and we're in constant contact with them, and they provide a lot of helpful information on the AI Act. And we are in contact with them also because a lot of these questions are also pertaining to data protection law to give a uniform answer to stakeholders. And I think this is really, really helpful also for companies and stakeholders that they get a view that is ideally established between several authorities. Exactly. I've already mentioned this. The idea is to establish these ties with other potential market surveillance authorities, so also from other member states where we think they will become competent, and the already established market surveillance authorities from other product safety areas. What we also do, of course, is we participate in the already established relevant groups. So this is the AI board, that is the official board coming from the AI Act, but also in the informal groups, such as the group on competent authorities on AI. So this is the CA at AI group, where already market surveillance authorities, or the ones that are potentially becoming these, are having exchanges on a very, very informal manner. This is extremely helpful. And also NOLEFA, which is the idea is that this is the Article 84 of the AI Act, a union testing facility that is also doing very important work in this area already where there's no official mandate. So thank you so much for your attention. This was a very quick, going through a bit of our priorities and challenges with the focus on this AI regulation. And if there are any questions, I'm super happy to take them. Thank you.